Hello and welcome to the deVere live webinar series. My name is William Trayford and this is our 16th webinar. And today the topic is how to launch a legal and lasting legacy. I'm delighted to be welcoming Natalie Smith from Lutea, Hong Kong, to be talking all about wills, last testimonials and succession planning. It's going to be a really enjoyable webinar. But before I hand over to Natalie, I just want to run through the format for today, just to make sure you're all aware, especially for those that haven't joined us before. So first of all, we want to know what your opinion is and what your situation is. Okay, so we're going to do a poll that's going to pop up in a few moments, and we're going to ask your opinion. Then I'll be handing over to Natalie, who will be doing a presentation, running through everything that you need to know about the topic today. And during that, hopefully, you'll have lots of questions. So what you'll be able to see at the bottom of your screen is a chat box. Okay, so in that chat box, you'll need to select all panelists and attendees, and then you can put your question in there. And what I'll do at the end of Natalie's presentation is then I'll ask her those questions and we'll be able to get the answers from the expert. Okay, and then after the Q&A, what we'll give you the opportunity is you'll be saying, okay, there's lots of information there, but what does that mean to me? So we'll give you the opportunity to reach out and find out more information and get some more detailed information about your own situation. Okay, so with that, I would like to launch this poll. So what we want to know is, when was the last time you updated your will? Was it less than 2 years ago, 2 to 5 years ago, 5 to 10 years ago, more than 10 years ago, or never written a will? So when was the last time you updated it? Less than 2 years, 2 to 5, 5 to 10, more than 10, or have you never written a will? So I'll leave that up there for you to answer. And with that, I would like to introduce Natalie. Natalie Smith works for Lutea HK. She's a director and lawyer with over 20 years experience. And I must say they are the experts in wills, trusts and succession planning for the international market that we're all in. And with that, Natalie, I'll hand over to you.
Thanks, William. Good evening, everybody. I know that the wills and succession planning side of things is not the most, the best topic to discuss, especially on a Tuesday evening, but it's one of the most important things that you will do for yourself and your family during your lifetime. So, what I'm going to do today is just run through a few common questions that we generally have, that I come across quite a lot. And by the end of the webinar, I do hope that I've covered most, if not all, of those common questions and any other questions you may have. So, the most common questions I have, when I can just remove the poll off of my screen, if you can bear with me, sorry. It's not moving. Here we go. Sorry about that. So, common questions that I do have and receive on a daily basis is, why should somebody make a will? I think it's quite an obvious question to ask, and the obvious answer is to take care of your loved ones. But not only that, it is wider than that, which we'll cover as we go through. What is the law of succession? So quite often you will hear about succession planning or estate planning. The law of succession is what governs everything to do with leaving legacies, your companies, what's going to happen with your companies, who's going to look after your children, and what governs the law of succession. Which then leads me on to one of the other common questions of, what happens to my children if I die? A lot of people think that it's very simple. You name somebody in your will, or you have a godparent, or somebody that you just trust who knows that they're going to look after your children. Unfortunately, under many jurisdictions, that doesn't actually happen. And then finally, what is domicile? Now, domicile is quite critical when it comes to tax planning, especially for some of the common law countries and some of the civil jurisdictions as well. Some of the common law countries that have quite heavy tax duties, like the United Kingdom. So England and Wales, for example, anything over, for one person, over the value of £325,000 is taxed at 40%. So you're taxed during your life, and then you're taxed, or your estate is taxed on your death, and then quite often your family or friends are taxed when they then become the beneficiaries, depending on their domicile and where they live. Which brings me on to the law of succession. So which law applies? Now this really does tie in quite a lot with domicile, but mainly how it works is it depends on where your assets are. So it depends on where you are, where your assets are, whether your assets are movable, such as bank accounts, stocks and shares that you can encash, personal possessions, paintings, cars, etc., or whether they are immovable, such as land and property, which is obviously quite obvious. Now, with regards to the law of succession, that governs your estate, but it doesn't just finish there, because not everybody can leave their estate to who they want. Now, the idea with a will is that you're given testamentary freedom to enable you to leave your estate, wherever it may be situated, to whoever you might want to. And it doesn't matter whether it's a charity, a family member, a friend, and it also can include, it's just come to me because I had a very bizarre question about guardianship of pets. And we've managed to draft a valid clause to go in a will for a pet. So making a will gives that person that testamentary freedom to deal with everything that they love and care about and those that they may leave behind. But, oh, sorry, not everybody has testamentary freedom. Now, this also, again, goes back to the situate of the assets and also your domicile. So, for example, Muslim countries and civil law jurisdictions do not necessarily give you testamentary freedom. That means that you cannot leave your entire estate to whom you so wish. There are laws that govern it called the forced heirship regime. And what happens is you're then governed by who you can leave your estate to. They tell you exactly who it can be. And then you have a free estate, a percentage that you're allowed to leave to who you want to leave it to. So with regards to testamentary freedom, where you've got the forced heirship, for example, in an Arab country, if you are of Arab religion and domicile, if you were born there, for example, you've got domicile of origin there, you are told what to do under Sharia law. So you have to leave your estate to who you are told to under Sharia. Now that means quite often that certain members of your family would not be entitled to inherit. So quite often in some Arab countries, it will be a case that your wills that you make have to be drafted and lodged with a specific body to ensure that it passes to the male heirs. So if you've got two daughters, they'll skip your daughter and they'll go to your brother. And then if your brother's got two sons, for example, it will go to the sons. So you don't actually have any freedom under the forced heirship there. But generally under civil laws jurisdictions, which a lot of European countries are, such as France, Portugal, Spain, Italy, not so much the UK, but there you've got your estate is generally divided into two. So the forced estate, and they say, right, there's a percentage of your estate that must pass to your direct descendants, or if you have a surviving spouse, to your spouse and then your direct descendants, which is quite fair because quite often that's who you want to leave your estate to. Then you've got the free estate, which enables you to then make legacies to perhaps other family members or friends or charities, and then you may wish to leave a percentage of your estate to anybody or any organisation you so wish. If you don't make a will, whether it is to pass your forced estate and your non-forced estate, or whether it's just have full testamentary freedom, you will then find yourself, well, you won't, it will be your estate that will find itself intestate. Now, this is similar to the forced heirship regime. Basically, the rules govern who gets what. So, for example, it will depend on the size of your estate and the value, and also the contents of your estate. So it may be, say, under a common law jurisdiction, that your spouse would be entitled to, say, up to 500,000 UK pounds, and your personal effects, so your pictures, your clothes, your furniture, vehicles, that sort of thing. But then the remainder of the estate will be put onto statutory trusts, and it will follow the statutes law that goes back to 1925. So it's quite dated. There's been a few updates along the way on trust law, but not very many. So it goes back to around about 1925, and it will say that your surviving children, now searches would be made by the administrators of your estate, who are those that are appointed either by the court or those that are entitled to your estate, such as your spouse or adult children, and they have to make adequate searches, place notices in local gazettes and newspapers to make sure there's no other children out there, for example. So you could find that half your estate is going to a child that your spouse maybe didn't know of, or you didn't know of, and then the other half is on statutory trust for your spouse, who doesn't actually have any entitlement to it, but can merely take income from it. And then the balance of that is then left to your children. And it all really does depend on who survives. So if you don't have children, it will be nieces and nephews. If you don't have nieces and nephews of whole blood, it will be of half blood. Then if you don't have those of half blood, it will be cousins of full blood, cousins of half blood. And it could get so diluted that you don't actually know, or actually your family, those that you leave behind, don't actually know who half these people are, or they may know that you perhaps didn't like them. It could be something as simple as that. Now, the rules do differ a lot, as I said, with common law jurisdictions and civil jurisdictions. So common law, which is places like Australia, New Zealand, Singapore, Hong Kong, the UK, have the set rules. So it will go via the family tree. But then you come back to linking into that forced heirship regime. If you don't have a will, that section of your estate that is the free estate will end up going to perhaps a male relative 3 times removed that you don't actually know, and your family could lose out. So the most important thing really is to ensure that you have written a will, even in a civil law jurisdiction. China does have its own laws with regards to intestacy. Again, it dictates who your estate is left to. And it's kind of a forced heirship regime there too, but not so much as the European jurisdictions. So by ensuring that you have a written will, it will ensure that your estate goes where you want it to go. But it's not quite as easy of just having one will, which we will come on to. So going back to what I said earlier, it depends on the value of your estate, where your estate is situated, and most importantly, whether you can pick it up and move it, whether it is movable or immovable. Which takes me on to the will itself. So generally, it's quite, it sounds quite basic. Generally, the requirements are last will and testament. And those words are so important, because otherwise people do not know it's your testamentary disposition. This is what you want to happen upon death. And what you would hope is that each time, because you can make a will as many times as you like, you revoke all previous wills. Excuse me. But you must remember that if you do have more than one will covering different assets in different jurisdictions, you must not revoke the will that you wish to still stand, For example, you have Hong Kong assets and you have and you live in Hong Kong and you have a property in China. So you would have a Hong Kong will disposing of your Hong Kong assets, and you could, there's no necessity to do so, I'm just using Asia as an example, you could have a separate will that extends only to that property in China. So if you then want to make a new Hong Kong will, what you must do is ensure that you do not revoke all previous wills. Instead, you would say this revokes all previous wills and testamentary dispositions made by me, excluding my will made in China on and then the date. And obviously, and this is very obvious, but it's so common that this doesn't happen. You have to sign and date your will, and it has to be in the presence of two disinterested witnesses, so completely independent, who are over the age of 18 with sound mind. You should have one or more beneficiaries in the will. Again, it seems quite obvious, but quite often people will say, oh, I just want to leave everything to my partner, or I just want to leave everything to my niece or my child or my nephew, and they don't have a substitute. And what happens if that person doesn't survive you, or if you're traveling together and God forbid something happens to you, there's no substitute. So what then happens is the law of intestacy kicks in, and it's as if you died without a will. And the only part of that will that would remain valid would be if there was a legacy to, say, a charity or to a friend, and there are executors appointed. But quite often the executors are also the beneficiaries if the estates are not complicated. So you might appoint your partner as sole executor and sole beneficiary, and you think, well, that's great because my will's done. But if you are traveling together, or God forbid you die within quick succession or together, then what will happen is you will die intestate, because there is no executor, there is no beneficiary. So that's why it's really important to have a substitute or more than one beneficiary. And as a lawyer, I will say this, it doesn't have to, by law, be drawn up by a lawyer. You can make a homemade will, only there are so many pitfalls. And this goes back to the signing and dating of the will. The amount of times a client will say, I've got a friend or a relative that's passed away, this is their last will, would you please assist us with getting the grant of probate in Hong Kong or in China, in the UK, or wherever it may be. And I look at the will and it's been executed absolutely fine, except for the fact that the beneficiaries are actually the witnesses. So what then happens is those beneficiaries, their gifts lapse. Their entitlement lapse. They don't get anything. And if there's no substitute beneficiary, then the law of intestacy then kicks in again. So quite often, I would say to clients, I'm more than happy to send you your will to sign, especially when I'm dealing with clients in, for example, in Shanghai with deVere, and at the moment, due to COVID, etc., I can't get on the plane and come over as easy as I could otherwise do. I will send them their will, but I will caveat that they will have a 1 or 2 page step-by-step plan of how to execute your will. And it may seem really straightforward, but it's so easy to make a common mistake. I've even had a case where I asked a client to sign their will where indicated in pencil, as in I put their initials in pencil, and they signed their will in pencil and sent it back to me. So it's really important that if you are going to make a homemade will, that you either get it checked over by a lawyer that's used to drafting wills, or maybe actually just take professional advice to see whether or not you can, make a simple will. But I would suggest that with this day and age, it's probably best to speak to an experienced professional on the basis that we have assets all around the world. We have sometimes second families. we have step relatives, you know, adopted children. The world is such a different picture as it used to be. So this goes back to the revocation that I was talking about. So it's, should you have one international will, or a will in each country? Or if you're in China, you might think, well, why not just have a Chinese will? Well, the reason that I think this is important to discuss is because with an international will, you have this situation where you have different regimes and different laws applying, and they vastly differ. So you've got some countries with the forced heirship regime. Well, they're not going to recognise the international will, because the international will may be made under common law, because you want to give away the whole of your estate, and it doesn't get you away from the forced heirship regime. So for example, I have what I call a worldwide will, so an international will, and it covers my assets worldwide, so Hong Kong, UK, but it excludes Portugal. So Portugal is like my second home, and it excludes Portugal on the basis that there is a forced heirship regime. And I have in my will saying it extends to all my worldwide assets, except for those assets in Portugal. And then the Portuguese assets are covered by a Portuguese will. And that will, I had to ensure, then says that it does not revoke any earlier wills, because otherwise it would revoke my worldwide, my international will. So for that reason, it's really important to take professional advice on the succession laws. So where you've got your assets and what laws apply, because it's not as simple as just having an international will covering everything. With regards to why not having a Chinese will, well, you can. There's no reason why you can't. But China recognises a will made by foreign residents. So non-domiciles of China can make a will, and it will be recognised under under Chinese law. Even if I make a will in Hong Kong and I've got an asset in China, it will be recognised. My Hong Kong will be recognised in China. And what you would then do is, through the probate process, you would get it resealed in China. So it gets the probate approval, so that your estate can then deal with those assets. And a lot of people say, well, you know, I'm living in my non-domicile country. So I'm living away from where I was born, from where I know. I'm away here for indefinitely, perhaps, or maybe 5 years. And we've now got children. So do I need a will if I have children? Well, the answer is you don't, actually. But you know, it's wise to have them. The reason being, in your will, you appoint guardians. And this is where it's really, really important. Again, depending on where you are living and depending on what the local laws are with regards to children. So for example, in China, if you have a will, doesn't matter whether it's an international will, Hong Kong will, UK will, European will, you have a will and it extends to your assets in China. And it also states in that will that you appoint 2 friends, for example, to be the guardians of your children, if they're minors when you pass away. So if you're a couple, once you've both passed away, if your children are minors, you have a guardianship clause. Now, the thing is with that is, if they're not living in China, especially at the moment because of COVID, it could take them the flight, the booking of the flight if the airlines are running, and then 14 days quarantine before they can even get to your children. So the Chinese sort of social services, if you like, take the children. And they take them to you know, they look after them, don't get me wrong, but they take them to like a home for children. And under Chinese law, depending on the province or whereabouts you live in China, depends on who looks after those children before the guardians can get there. And then the guardians then say, well, I've got this will appointing me as guardian. And they say, well, you have, but they're in our care now. So what you need to do is you need to either have a guardianship deed that helps back up the fact that you've got Chinese appointed guardians, which is temporary until those appointed long-term in your will can get to China to take over the children. Now this works in Hong Kong really well. So in Hong Kong, you have a temporary guardianship deed, and you might have appointed somebody in Singapore and under your will, and you think, well, that's all right because only 4 hours flight away. Well, it's not all right, because at the moment, with the world as it is, it's not as easy as just getting on a flight and coming to get the children. So you have a temporary guardianship deed, and that guardian is on the ground in Hong Kong. They look after your child until the guardian appointed in the will comes over. There's no legal formalities to go through. They can just then take the children in accordance with the terms of your will. In China, it's not as easy as that. And although a guardianship deed is not written in law in China, it really does go some way in helping, and I've seen this happen, in helping to rebut any assertion that your children should go off with the local authority. Basically, it's appointing a friend on the ground, or your helper, or somebody like that, or a teacher, to look after your child until your guardian can get there. So yes, for that reason, I would say a will is very important, but not a case that you have to have one, but I think it's really important. And also, if you die when your children are minors, what's going to happen? You know, you need to be able to direct that the money is going to be held in trust, it's going to be put forward for their education, consider what needs they may have in the future, where you want them to live. Is it where you reside now, or is it where you're originally from? You know, and all these sorts of things can go in that will. And the trustees, who are the executors of your will, carry out those wishes. You can have a letter of wishes guiding them as to where you want your children schooled, what monies you want advanced at what ages. So again, for that reason, I think it's really important. Which leads me on to domicile. So with regards to domicile, this is really, really important. Again, I mean, everything's quite important with wills. This is important mainly from a tax perspective, really. If like me, you're UK domicile of origin and you don't want to get caught by the UK tax authorities when you've not been living there for many, many years, and you've got no, you know, reason to be going back there, and you've made your life somewhere else. And then when you die, they say, oh, well, actually, you're still domiciled in the UK. You didn't cut your ties. There's no evidence that you know, you're not, that you weren't ever going to return. And so in a will, you should sort of state, you know, you're a resident here and you intend this to be your home. You can change it at a later date, but for those reasons, you've taken a domicile of choice in that country, because a domicile of origin actually goes back to your father's domicile. So they can look that far. And if you're legitimate, if you're illegitimate, it goes to your mother's domicile. And then whilst you're a minor, your domicile of dependency is always that of your parents. And it's not till you're an adult and you leave home and you may move to another country to work, you rent or buy a home in that country, you meet somebody, you settle down, you have children, they're schooled in that country, and you start to kind of sever a few ties in say the UK or New Zealand, Australia, and you then acquire that domicile of choice. Now, in your will, it's really important to put a very short domicile statement to that effect. And it's as simple as saying, so for me, I'm a British citizen, but I live in Hong Kong, and it is my intention to permanently reside here, and my resident Hong Kong ID card number is X. For that reason, I've taken the domicile of origin, domicile of choice. So it's something as simple as that. You can also have a separate domicile of sort of a deed of domicile, if you like, a domicile statement, setting out where you've been working, what countries, you know, and how you've not spent too much time in your home country, so you shouldn't get caught by there, or we're going to tax you upon death, or your estate upon death, say 40%, because on your worldwide estate, because we think that you're still domiciled in whatever jurisdiction. So it's really important that in your will you have a very short domicile statement. So just finishing up on here, and I hope that it's made a few points and given you a few things to think about, but the planning points that I always tell clients, this goes back again, and I keep going on about it, it's consider domicile, the nature, the extent, the value of your estate. So whether it's immovable, whether it's movable. And in particular, you know, if you've got a company, shares in a company, where is that company, you know, the registered office? What you don't want to be doing is leaving shares in a company just bulked into your estate to a beneficiary in another jurisdiction that is just basically going to be paying capital taxes on everything. And also, you don't really want your shares to just be diluted. You may find that you've got a really lucrative company and you haven't put any planning in place, and it's not in the Articles of Association as to what's going to happen if you and your director, co-director or whatever die, you know, what's going to happen to the shares, who's going to take over the company. So it goes right down to that. So not just your personal wealth, but also your business wealth. And this is where it's really important to liaise with your lawyer as well as your financial advisor and your accountant, because they look at things, or we look at things differently, and that way you cover all bases. Also consider what is to happen to the estate. So, you know, think about inheritance. Do you want it going to somebody that's 18? If it's a lot of money, I wouldn't. I'd wrap it up in trust for as long as I could. You know, you want to think about protection. Do you have a vulnerable beneficiary in the family? Do you want to protect family heirlooms? Do you want to protect family, I don't know, businesses, farming industry, that sort of thing? There's a lot of farming families that it passes through the generation, and it continues to do so, and it's very tax efficient. You also need to think about, where are your wills? You know, are they in the right jurisdictions? Do you have a worldwide will covering your common law, and then you have civil jurisdiction wills? What are the probate procedures in those countries? What you don't want to leave your family doing is spending fortunes and months, if not years, trying to sort your probate out. You know, what you want to be able to do is make sure that you've taken the right advice on the succession law, so that we can cover what we can under one probate jurisdiction, sometimes two. But, you know, by taking the right advice on succession, then you can start to plan how to draft your will, what you want in your will, and also what the probate process is. And that leads me on to the tax planning. Again, succession, domicile, who is to inherit. Charities, for example, get tax exemptions. Family don't. So it's all about linking it all in. So it's like one big estate plan. You think about what you want now whilst you're alive, who you want to protect, what you want to happen to your estate, the tax implications, where the assets are, and you need to look at it as a holistic picture, because only that way will you get the right outcome for yourself during your lifetimes and your family. And as I say, you can change your will as much as you like, as long as you're of sound mind and you're alive. And then you must consider restructuring the ownership of assets. If you're a mixed domicile couple and you own a company and all the shares are in the partner's name, that's going to be, their estate is going to be taxed at 40%, opposed to their partner whose estate can be taxed at 0 because there's no death duties under their domicile. What you need to then do is think, maybe I want to transfer some of these shares in this company, or maybe put it through a trust so that it benefits my spouse, my children, my nieces, nephews, friends, whoever. And there are so many planning points that you can do to take some of that pressure off when it comes to tax planning. Most importantly, implement your wills. So once you've considered points 1 to 4, that is when your wills come into play. Obviously, you might want to, because sometimes it can be a long process, so you might well want to have a temporary will in place, and then we'll just add to it as we're looking at restructuring ownership of assets, companies, shareholdings. We're looking at family wealth, immovable assets and movable assets, and most importantly, I would say domicile and tax. So that brings me to the end. I hope you found it useful. And if you do have any questions, I'll be very happy.
Yeah, excellent. Thank you so much, Natalie. That's brilliant. We have had some questions come in. What I'm just going to do, could you just stop sharing? Or I think I might be able to.
Yeah, I was just clicking on the button. This is all very new to me, so I have my IT man that's going to stop sharing.
Yeah, perfect. Good. So everyone should be able to see both of us now. Yep. So first of all, that was excellent. Thank you so much. Good information, and I think you've covered off a lot of what's in people's questions, but we will cover over them again as well. I'm going to give you the results of the poll, and I don't think the results will surprise you, Natalie. So it was 69% have never written a will.
Oh, goodness.
6% more than 10 years, 19% 2 to 5 years, and 6% less than 2 years.
Right.
Is that similar to your experience, or what do you think?
Yeah, I would say my personal experience would be pre-COVID. I would say probably 75% of people had never written a will because they made the assumption that it just automatically passed to the wife, the husband, the kids, the parents, whatever. COVID come along, which is, you know, it's just been tragic for the whole world. It come along and people started to get in touch with their own mortality a little bit. And it's a really sad thing. You know, the pandemic has made people think that way, but it's true. You know, all of a sudden they're thinking, my God, you know, my family are in this country, I'm in this country working, what happens? So I was hoping that it'll be less than 69%. But...
Yeah, that's the sad reality of it, I guess. And then, I mean, on that, is there a time you generally suggest about how regularly people should review their wills or update them?
Yeah, I mean, it used to be that, like, many years ago, I don't know, 15 years ago or something, the world seemed a bit of a smaller place, and people generally started to maybe just look at their wills when circumstances change, like they may have lost a relative, an older relative, and received some inheritance, or, you know, they thought, well, I'm setting up a business or I've got a child on the way, and you would find that it might be every, say, 3 to 5 years. What I say to people is there's no actual time limit, you know, and you don't have to, you know, keep updating it, but, you know, because you can't force people to do these sort of things. But what I would suggest is every time there is a change in circumstance, you should just get that will out and just have a look. And even if you pick up the phone and say to your lawyer, listen, you know, does my will cover a second child because we're expecting another child? Quite often it does, because it says the existing child and any other children I may have, you know, but it's just worth checking. And I think what's really important as well is that if your wealth significantly increases, they should be speaking to deVere, and they should be saying, look, I've got this, what do I do with it? And you're saying, well, you should be doing this, this and this. And then from maybe a tax planning point of view as well, they may need to then look at other structures. You know, how would they hold those investments? Maybe it's through a trust or in their own names now, but their will could have a will trust in there that would keep those investments producing income for future generations. So it's really a case of just as and when circumstances change.
Yeah, absolutely. And you're exactly right. I mean, in terms of financial planning as well, there's a lot of things that need to be thought about for estate planning as well. And then, I mean, just on another sort of significant event, a lot of our clients obviously spend a few years living in one country, then move to another country, not necessarily back to their home country or domicile country. Would that be a significant event that they'd need to update their will for if they move countries?
I think it's always worth having a look at it, and it's always worth. So I've had so many people where, sadly, due to the situation, have had to, because their companies have had to lay them off, or they're sending them back to another jurisdiction, where they've said to me, look, I've got a Hong Kong will, for example. Well, it might be a China will, because I've got lots of Chinese clients too, but clients over in China as well. But in the case, I've got this, but I'm going back home to New Zealand. What do I do? And I look at it and I say, well, actually, it extends to your worldwide assets. It's under Hong Kong law, but it's a common law jurisdiction, right, as is New Zealand. So don't worry about it. It will be recognised. The only thing that will be overlooked is maybe if you've put a domicile clause in there. You know, they'll say, well, your domicile of New Zealand's now revived, so we ignore that bit, but it would still be valid. But what I would say is, if you then start to acquire assets in another jurisdiction, you should, whether it's civil jurisdiction, so if you go somewhere like Spain, you should make a will in Spain. You have to make sure it doesn't revoke the will you've already made, because that could still cover the rest of your assets. So, yeah, I mean, sometimes they don't have to be changed. But I always suggest that once you get to that next jurisdiction, it's worth having a look.
Yeah, absolutely. So one question that came in before in our WeChat group. So what are the main aspects to consider for international families that are here? So I basically a foreign partner and a Chinese spouse with assets in China.
Right, okay, so foreign partner, do we know what jurisdiction? We don't.
I think this was more to do with, I mean, I know the person who sent it in is from Mexico, but I think he's also asking for, in general, sort of what an expat would need to.
Right. Okay, so from an expat's point of view, so you have, depending on where you're from, depends on sort of the estate duties, okay, the death duties. So, for example, here, there are no death duties in Hong Kong, right? So what I would say is, if you've got, say, someone who's from, I don't know, the UK or Australia or somewhere like that, and they marry a Hong Kong-born lady or chap, then I would say get the assets into their name, right? Or start sharing assets, because what you don't want is to be taxed on your worldwide estate. So the same can be said for China. If you set up home and you acquire assets in China, then and you've got assets in other jurisdictions, your spouse, who is Chinese, should make a will in China, because he or she is China domicile of origin. So they must start with that will. But as a foreign spouse, you don't have to follow that. You can have a will made under, depending on where your assets are, made under the laws of wherever. And you can also, if you wanted to have a Chinese will, the Chinese, the way it devolves without a will is quite convoluted. So it's always a good idea, a Chinese spouse, to make sure that they put their wishes in that will, because unlike Hong Kong, it is registered in a registry there, and you know, it's quite a strict regime. And as a foreign spouse, you need to consider, you know, if you're inheriting assets from your Chinese spouse, what implications are they going to have on you from a tax perspective? If you're leaving assets to a Chinese spouse who says, well, we don't pay, you know, those sort of death duties, I don't want them, because I don't want to be paying, you know, different duties in different jurisdictions, you need to consider that as well. So it really does depend on the domicile and if you can acquire that domicile of choice. Yeah.
Okay. So we had another question. There's two questions from Deshaun and from Max, similar, and it might be a bit too specific, but it's in general. If I have a pension in Europe, property in Thailand, and I live in China, so both of them are similar. Pension / liquid sort of assets in Europe, physical assets in Thailand, Southeast Asia, Taiwan, Japan, and then living in China. What sort of structure would they need?
Well, I would suggest you have a worldwide will. So you could actually do a worldwide will living in China. You could do a worldwide will under the laws of PRC. So they would extend to all your assets everywhere else, although Thailand's property is completely different. That doesn't fall within wills or anything, you know, the Thai property. So I would suggest you have a Thai will. So you could have a worldwide will made under Chinese law in English, because they would recognize that extends to all your assets. Now, with regards to liquid assets, in Europe, that's fine. It's where they're immovable in Europe, that's where you need to have those wills in those civil law jurisdictions. But you could also choose a jurisdiction. So, for example, if you're domicile of origin somewhere and you're not intending on taking a domicile of choice in China, because you've got no, you know, you're going to move to see your days out in Thailand, you know, you could make a will under a different law. So that's the testamentary freedom side of things. See, that comes back to that. But I would say definitely at least a worldwide will maybe excluding Thai property, because that's a bit of a funny regime.
Yeah. Okay. We've had two. I'm very conscious we're short of time. We've had two more questions that come in that are very specific. So Daniel and Dione, I would suggest you get in touch with Natalie, and we'll give you the opportunity to do that afterwards. It's very, very specific for your situations. And I think it'll be a similar sort of answer. It will depend on lots of different things. So
Yeah.
with that, Natalie, I'd like to say thank you so much. But before I do, let me just do one more poll. And on that, because as we know, I think more than any topic we've done, I think actually this is really down to your specific situation, because everyone's got such a different background, such different scenarios they've come from. So if you want more information, if you want to find out, you know, your situation, what you need to be doing, and whether you're, or even if it's reviewing your existing situation and just to get a clean bill of health saying, yep, you're absolutely fine, don't worry about it. Answer one of these questions. How you'd like us to contact you is via email, WeChat, phone call, video call, visit our Shanghai office. I'll leave that up there for you to reach out and ask, see how I can get more information. But with that, Natalie, thank you so much for your explanation and answer questions.
That's great. Thank you.
Excellent. And thank you all for attending, and thank you for your excellent questions. I know this has been a very popular one, and we'll be sending out follow-up emails with more information as well. And also thank you for your donations throughout this webinar series. We've been supporting Give to Asia. It's been helping the frontline COVID-19 response. It's been going, we've been doing this for 4 months now. Amazingly, we didn't think we'd still be doing these 4 months later supporting charity, but here we are. But it's excellent work that they're doing. So thank you for your donations. And with that, thank you all. Thank you, Natalie. Good evening.
Thank you. Good evening.